Welcome to Tony at 12. I'm Tony LeBlanc, and today I'm in conversation with Alistair Kelman, a barrister who is the co founder and CEO of Safecast Limited, specialising in solving the conundrum of computer evidence in court proceedings. Alistair, good to see you.
Thank you, Tony.
And first of all, can I thank you very much for the kind introduction to Paul Marshall? As you know, we did the post office one last week, and
Mhm.
we've got some really favourable comments from some of the viewers, which is very, very good. So
Mm.
up to a point, this is a sort of continuation, isn't it, of the post office bit up to a
It, it,
point.
it, it is a bit. My engagement with the post office case is somewhat peripheral. It came about through rather an odd set of circumstances. So it's useful if I outline the background on that. Um, Basically, I'm a little different from the conventional barrister. I read minerals engineering at Birmingham University in the early 1970s. And I was then faced with the prospect of running a flotation plant in Zambia for the next 30 years, which is what my colleagues were doing and things like that. But I decided that I really didn't want to be an engineer. What I really wanted to become, because I discovered this in my final year, was a lawyer, a barrister. And I then discovered there was a special course which called the G1 course, which had just been created, which allowed graduates in non-law degrees to get the equivalent of a law degree in a single year's study.
Mm.
So I joined this pioneering course and came down to London and got and basically studied first for this 1 year. Then I did the bar exams to become a barrister and the full bar course on that. Ate my dinners in hall in the Inns of Court. And decided to did a pupillage first of all in patent chambers and then in chancery chambers. And after that, I also went to evening classes that want to pick up a computing qualification. So I was really working hard on these in getting going on these things. And basically, towards the end of the 70s, I set up a specialist practice in the law relating to microelectronics and computing. And I wrote a lot of articles in the computer press and got myself known by that route. And one of the things I started to do was I started training police officers in the investigation of early computer crime. I trained them at the Peel Centre in Hendon. And the job there that they had to do was how to freeze the evidence, how to ensure that they could pull all the evidence together to determine that a crime had taken place. And this meant that they had to understand how computers worked and how the evidence came together. But also around this time, I was working with the British Computer Society, and I wrote a report for them on looking at computer evidence with a less than thrilling title, "Admissibility and Reliability of Computer Evidence in Civil and Criminal Systems," which was a report that went to the government. And this was for the professional board of the BCS on that, which was headed up by a person called Richard Sizer. Richard Sizer and myself became good friends. He was at the Royal Aircraft Establishment, and we decided to write a book about computer evidence. And that book is The Computer in Court, which I can hopefully
Yeah,
hold up
it's in
on that one.
focus. Yeah,
That's
yeah.
it in that. And the book basically came up. It was an idea that I had that let's come up with a situation where a lad is charged with a crime he didn't commit, and it all arises through bad computer evidence and failures in the system to actually deal with these things on hand. And I based it on a case that I actually worked on. So I knew the facts and the background of that, and we wrote this imaginary case, and it's so that the book came up with this little drama in it. And well, several things happened. First of all, it was highly commended by the Law Commission, and it was used as a training aid across the field. But one of the things that came about from it was that I ended up uh, trying to work out how the problem could be solved.
Yeah.
And I came up with a solution which is referred to today as the seven statement test. And that is basically what I said was that before you could put in any computer evidence, you had to have evidence upon which you could ensure that the computer was working properly. And I came up with a standard form, a sort of best practice to enable that, how that could be done. And I set out in the book the idea that this is what should be done in every single case. Well, two things happened after that. I was completely ignored, my suggestion for the 7-statement test. But nonetheless, in practice, in the cases that I worked on, I actually was advising that this is what people should do. Well, to cut a long story short, I got involved in the post office case many, many years later when back in 2020, after I'd left the bar, in 2023, I was contacted by a forensic software expert, a person called James Christie. And he had been commissioned by a learned journal to write a paper on the reliability of computer evidence and why the Law Commission came up with this particular recommendation. And I'd been working on the side I'd been watching the post office case and what had been happening over that time. He wrote a 17,000-word peer-reviewed paper for the Journal of Evidence of Computer Evidence, which was published by London University under their provisions. And in it, he established beyond reasonable doubt that the Law Commission had misrepresented the work of myself and all the other experts. What had happened was that in 1995, they were lobbied by the Post Office to get rid of this provision so that computer evidence was inadmissible. And they said because it was highly inconvenient for them in prosecuting all their postmasters. Consequently, to do this, the secret lobbying went ahead. I suspect some very bad practice went on, because thereafter, all the work of the independent experts was misrepresented. James Christie actually uses the word fraudulently in these circumstances by the Law Commission to try and get these measures through. And it was successful, and in 1999, they abolished the requirement for computer evidence to be admissible, to be reliable for it to be admissible.
Yeah.
That's it. And by that time, I'd left the bar. I was busy coming up with my various inventions and the rest of it. But when James Christie wrote to me and asked me about this, what actually had happened at the time, I gave him the latest version of the Computer in Court, because I'd revised it when it went out of print and put it free on my website. And working with James, we came up with a solution whereby I thought, well, okay, the law's made a terrible ass of these whole affairs. Let's see if we can rectify the situation and show that this never happens again. And fortunately here, the new head of the Law Commission is a very different one from that at the time in 1995. The new head of the Law Commission is Mr. Justice Fraser, who was the judge they tried to nobble in the Post Office Horizon case. So what I did was I sat down and I wrote an article for Computer Weekly where I said, okay, they've misrepresented what I and the other experts did. How should we go about solving this problem? And the solution I came up with is based partly upon a piece of American legislation called the Sarbanes-Oxley Act, the SOX Act. Now, when there was major fraud in Enron and Wirecard and all these things in America, the US authorities decided to bring in measures to ensure that companies actually had to report properly on what they did. And so what I did was I looked at the American provisions and said, right, why don't we do something similar to that in the UK law? And I came up with an analysis. I took my original 7-statement test that I'd come up with in the work on that, and I revised it. I brought it up to date for modern technology, and I also used a thing called Bayes' theorem. Now, Bayes' theorems are wonderful things. It's about 250 years old on that, and it means that you can add probabilities together and do it in a particular way. A very it's very difficult to explain to ordinary lay people, but it is the technique by which you can actually properly weigh and combine evidence together. And it's used extraordinarily in all sorts of ways. You can use it to solve an Agatha Christie murder. You can use it. You can use it for all sorts of activities of this sort. It's used to get rid of spam emails. It's used to get through or do all sorts of decision analysis and things of that sort. And it's a very, very powerful mathematical tool, but it couldn't be used sensibly before computers were developed and rolled out. So what I did was I sat down and worked out how you could actually come up with a threshold by which all computer evidence should be, you combine all the risks together. If it falls below a particular threshold, then it should never be admissible, or admissible only on special terms. And if it came above that, then you could allow the evidence in. And this is the theory that I came up with and a method by which we could sort matters out. And consequently, in the papers that I ended up writing for the Law Commission, I put together for the government, I made a recommendation that the law be changed immediately so that all computer evidence is admissible if it is reliable. The updated seven statement test is brought into effect, and this is the key factor. If any evidence falls below the threshold of a Bayesian analysis, then there's a voir dire, as it's termed. You have a trial on that evidence to decide whether it is admissible, and whoever's putting the evidence in as it being admissible has to pay the costs of that voir dire.
Okay, so the whole thing would start on the basis of a separate trial, considering the computer evidence, and once you got to the situation where it was deemed to be in order, then the main trial could proceed. Is that right?
That's what would happen. But most of the time, the computer evidence would be admissible and reliable.
Yeah.
It's only in extreme cases that things go wrong. But it's the extreme cases that have led to all the problems in the post office case.
Yeah, the Horizon system.
That's right, and those things, and those happen, and they're going to be continuing to happen to an extraordinary extent, because these days you pick up a piece of computer evidence and you don't know where there are faults in it.
Yeah.
You need to have some guidance to enable you to identify those faults, but you mustn't be constantly making false claims that, oh, this is unreliable, when it is quite obviously reliable. Now, the best way that this could be done would be if any business wished to put in computer evidence, then it had on file a document which showed that its computer evidence was reliable in general terms, and then the specifics for that particular printout could be added at the last moment, looking through all the provisions that were there. This is the basic concept that I had in the seven statement test. But the extra factor that I've come up with on this one is that what I wanted to do was to find a way in which the market would drive this. So it's not going to be an unnecessary cost upon the industry and on that. And I thought, well, the best way of doing this is if you have a regulation that says that if you don't have a pre-written seven statement test statement on your files and handling it in the proper way and are able to produce this, if you don't have that, and a Bayesian analysis shows that your evidence falls below the key test of reliability, then any directors and officers liability insurance policy is invalid, void. Now that means that if you're the managing director of a company, or even the officials and the rest of it, and you're putting in evidence, you're personally liable.
Yeah.
And the best way to have dealt with the post office officials would have been to have made them personally liable for the crimes that they have brought about, because that would have brought clarity. That would certainly have stopped them doing what they did. and this is a market-driven system. So if they've properly invested in their business and they properly handle their affairs, then everything works as it should, and the justice system works as it should. But if you don't have this sort of provision in place, then you've created then basically you're going to spend huge amounts of public money on trying to either defend the indefensible or deal with matters that should never have been raised in the first place. So that's the summary of what I've put into to government, and it has been favourably looked upon by my colleagues, my other experts, and other lawyers, and the rest of it. But I don't yet know what the government is going to do in the circumstances regarding this. Nobody does.
But your hope would be that they would effectively issue, or rather have an Act of Parliament which would put this into context and make it a
Yes.
requirement that in future the people who actually provide the computer information have got it right, and if they haven't got it right, then there will be the penalty of losing their directors and officers insurance. Don't those directors though have a fiduciary duty in any case?
Absolutely. But the difficulty is this, that if it's very difficult, it's a very specialist task to actually show that computer evidence is reliable.
Yeah, that's the
And
point.
and consequently, everyone is taking other people's assurances. Oh, yes, this is perfectly true. This is correct, and so on and so forth. We've all seen problems with computer evidence over time. The biggest problem is that if someone gives you you never know what your computer's actually doing.
Mm,
You really don't.
that's right. And
It's
of
kind of
course, third parties can get into it, hack it, scams,
yes,
etc., etc. So, I mean,
exactly.
that's always going to be an ongoing problem. I do like this quote though from you. Must read this out. But
Yeah.
lawyers who can turn a grown man into a quivering pulp under vicious cross-examination do not know how to highlight latent errors in computer evidence. And that's
Yeah.
true, yeah?
Absolutely. That really has been the problem all the way through. And I think part of the problem is came to a little bit of background on this. When I came to the bar, I was very nervous about this because basically laws are sort of is a funny area where how should I say? It's a true meritocracy in this thing, but it kind of helps if your father's a judge and your wife's a solicitor, or it did in my early days on those days. And so when I came to the bar, I was dining in Hall, at one of the first dinners I had in Hall, and this person came up to me. It was looked like a very thin elderly man wearing a gown, and sat down beside me and said, "Hello, I'm Diplock." It was Lord Diplock,
Right. Okay.
and this was part of the dining ceremony. And I explained to him that after we got chatting and he was so friendly and the rest of it, I explained to him my concerns about coming to the bar because I didn't have the background on these things. I was an engineer and I didn't know what was the future going to be on that. And he said, well, look, I want to see 10% of the bar having scientific and engineering qualifications,
Mm.
because that is the only way in which we can progress and move forward safely in the world ahead. So with his encouragement, that's what happened, and that's what he recommended. And I set up my practice on that basis. And I'm afraid that while the bar has become far more women involved, far more people from ethnic minorities, far more people from different class backgrounds, and the rest of it, what it hasn't yet happened is you haven't had this mix of people from different disciplines. And that, the cross-fertilization of science and engineering that is needed for evidence to be properly evaluated, that needs to be something that is brought in. And hopefully, with the new Law Commission and the work that's going on over there, and the moves ahead to sort out the post office issues, that is going to happen. And you will have a bar and a practice which we can all be proud of.
Mm.
Because English, our judges are absolutely first rate, And the barristers that we have, my colleagues are very good in what they're able to do, both at the criminal bar and in the civil bar. And I want to be able to sort of expand their horizons in this new way to get justice working as well as we can. They've basically that's what I'm really focused on. All this material is free up on my website. I also taught for a while at the London School of Economics, a specialist course on information security and the law, and all my notes and everything up there are available to my students and the public at large, so they can carry on working in these areas. But that's very much an introduction to what we're doing and what the solution is going to be, Tony.
Yeah, and obviously, as time goes on and artificial intelligence becomes more available, that's going to make it even more difficult, isn't it?
Absolutely. The big problem that you've got is provenance. You do not know whether something is real or is being fabricated.
Yeah.
Whether whether this is a real interview with me, or if you're dealing with an avatar that's chatting at the other end of it. I could possibly put that together. This is the real me, honestly.
Yeah, sure. Yeah, we're pleased to hear that.
But it is a problem, and it is getting steadily worse as the rubbish comes out from AI systems, the hallucinations that they come up with. I've learned recently that AI may be wonderful, but an AI system can't successfully play tic-tac-toe with you because it can't work it out. And a 5-year-old child can beat it with a tic-tac-toe. There's still quite a distance to be able to go in getting these things working. But it's very useful for analyzing huge amounts of data and summarizing data in an effective way. That's one of the most powerful activities that we have in dealing with it, and that would enable the shorter representations to be long statements that I tend to come out with to be pithily précised into a form which could be accepted and put before a jury.
So are you actually in a situation now where you're developing that side of it? Yeah, artificial intelligence?
I'm not working on artificial intelligence itself. What I'm able to do is I'm able to advise on how people can use Bayesian systems on the web to do this sort of analysis. And specifically, I hope if the government does go ahead and implement some suggested reforms to deal with the question of computer evidence, then this will be a key part of it. There are great people like Lord Arbuthnot who've been working very hard on these provisions, and also Paul Marshall, of course, and the work that's going ahead on that. But one of it's going to take quite some time for this to get through, because you've got quite an education process amongst the judiciary, and there has to be proper training courses for the judiciary to explain it so that they are taught how best to go about accepting computer evidence.
This would include judges as well, wouldn't it?
Absolutely, that's a key necessity. In fact, what I would like to see is a mandatory training course for anyone who wishes to become a High Court judge. That they have to go upon these have to be trained up in admissibility and reliability of computer evidence, how computer systems go wrong. Because one of the funny things is this, that basically the failure characteristics of computers is entirely different. Give a quick example. If I have a physical camera and I'm clicking away with it, I take lots of photographs on that. Now, conventionally on a camera, if you had a camera, you just press the button, you knew that it worked, took the picking. With a modern camera, well, they break down intermittently. They can suddenly not take a picture, and there's no particular reason for it. Maybe it's got it too hot, maybe maybe it's an odd day for it, and the rest of it. But the failure characteristics is entirely different from that of a mechanical device, where if you think of the old steering in a car when it was physically connected,
Yeah.
when you actually had it on that, you knew if you turned to the left, it turned to the left, it turned to the right, turned to the right. Now it's all fly by wire, and you turn it, and it goes through a whole series of computations. Oh, you turn the wheel. And it will then make the connection. There's actually no connection, physical connection between the two. And that leads to new faults arising because computer systems fail differently from other devices, and you need to be able to build that into your analysis so that you know when things are going wrong, and I've identified when things are going wrong.
Marks and Spencers have only just got back online with their online
Mm,
shopping system because of a major hack.
yes,
Does this come into your remit at all?
it does. In that I'm very aware of the risks associated with systems of that sort. Again, what happened with them, I understand, is that they outsourced their activities to Tata,
Right.
and it was a security breach at Tata that led to the attack. The whole system becoming vulnerable. But the biggest problem that you have there is what you have now is in the same way that you have your web services providing you with email and the right. You have software as a service, SaaS. You also have ransomware as a service
Mm.
where you can actually go and commission these, buy off-the-shelf packages on the black market and use those and assemble them together. And all you need to be is what we used to call a script kiddie to put these things on hand and get involved in organized crime. Fortunately, I left the bar before the real criminals became active in that. I defended the original computer hackers, the ones that got into the Duke of Edinburgh's Prestel mailbox, and I got them off in the court of appeal and the House of Lords on that. So I was playing both sides to middle in those days. I was defending, training police officers on how to investigate computer crime, and defending the people that were charged with computer crime. So it was quite an interesting time to be in practice. But
Mm.
fortunately, in those days, the criminals that I was dealing with were not real criminals. They were just kids that were curious about computers, and consequently, they were doing things that broke the security of systems because the security was exceptionally bad. And that situation has gone on and on and on with more and more cover-ups over the years. Um, uh, there's a lot of material on my website for this, which is freely available to anyone to download and pull out on this time, Tony. So I welcome correspondence with people who, the students and that want to learn about these things, want to learn about that, and because hopefully with with goodwill on all sides, we'll come up with the right solution and restore British justice to its high reputation.
But at the moment, it's lacking. And
Yes.
the combination of the post office having the ability to prosecute and obviously having the ability to lobby and make sure that certain things that they didn't want to become admissible didn't become admissible is a major problem, isn't it? Do you,
It is
I mean,
that I'm
do you
afraid.
see, sorry, do you see them losing their prosecution right, or have they already lost it?
I that's a question I don't know the answer to.
Yeah.
I see that my there's no justification for the post office to actually have that power any longer. It's been privatized. It's been moved out. The there's no reason why you should have the ability to why the post office should be in that extraordinary historic role. But I'm afraid that the harm that is there goes right the way through into the depths of Treasury and government.
Mm.
Without doubt, this situation was known. It was known about in the Treasury. It was known about that this could not be relied upon, and certain people at very high levels just basically wanted to hang on to the money
Mm.
and stop. And I hope to see a good number of the post office people properly prosecuted in the end of the day. But I'm not holding my breath on that one, I'm
No,
afraid.
because it's an establishment matter, isn't it?
Exactly. And
Yeah.
the seeing Paula Venables blubbering in the court and knowing the roles that she took in this case, seeing the people in Australia, the key one of the key witnesses refusing to come back to
Yeah.
to testify.
Yeah.
Um, I really would like to see them extradited. You know, you always think of, wouldn't it be wonderful to move them all to Guantanamo Bay or something like that? The end of the day, because they really not be should be part of our normal society. But
Mm.
that's extreme. Let's calm down and look and come up with some universal solutions which are going to solve the problem. Because if it's we've got to compensate the post office people, we must ensure that this situation can never, ever
Happen
happen
again.
again.
Yeah.
And
Yeah.
that is the paramount importance of people within the profession. And I've got very good colleagues that are doing exactly that. People like Paul Marshall
Yeah.
is are leading members of the profession that can do it. So I've got great hope that these people will deliver. But it depends overcoming government.
But as
It's
Paul
funny.
identified the other day, Alistair,
Mm,
the situation is, as far as the post office is concerned, they're still stalling off on the payments. They're still being awkward on the compensation. And,
yeah.
I mean, really, the recent report, has basically found hell of a lot lacking in the post office. And you
Mm,
would have thought that let's clear it up, let's get rid of it. But these things
mm.
just drag on and on and on. And we see that with the blood scandal as well, don't we?
Yes, yes,
You
tainted
know,
blood.
it's almost as
Exactly.
if government says, well, if we leave it long enough, most of them will be dead, and therefore the amount we actually have to pay out ain't going to be too much.
I seem to remember a situation of it's a good day to bury bad news.
Yes,
Remember that quote?
yes, yes,
Yes.
yeah, yeah,
And
absolutely.
9/11, yes, exactly. So I think that that is an attitude, a cynical attitude in government, and I'm afraid that we do not have, in my view, the quality of civil servant that should be managing these affairs. When I look at pretty well near authoritarian states like Singapore, they have very good civil service that delivers a high quality of service
But
for
but you
people
have
that are
to
in it.
thank Lee Kuan Yew for that one, don't you?
You
He
have
knew how to
indeed, you
run
have
a
indeed.
country.
But again, it's that there it's how's it referred to? Disneyland with the death penalty. I think
Yes.
it's referred to, on that. There are some serious
But
problems
it
that
works, doesn't it? It works. They respect the rule of law, and we don't see that
yes, but
anymore in
I
England.
think what we're encountering in this country now is what you is referred to in China as the it's anaconda in the chandelier. Today, in anybody saying anything or writing anything or thinking anything, they're terribly afraid in any private conversation, anything that they're doing, that they're terribly afraid of is going to happen to them in social media
Yeah.
and being outed and things of that sort. And in China, they call this the anaconda in the chandelier, where you're sitting around a dinner party. You think you're perfectly happy, but there's an anaconda sitting in the chandelier that's going to come down and bite your head off if you say anything that's wrong. And you can't, and that I think has happened in British society
I mean,
to
I've
some
got to
extent.
the point where if I meet somebody for the first time socially,
Yeah.
I say woke or non-woke, and then design everything around that. But there we
Exactly.
are. Alistair, I'm
Exactly.
sorry to have to say that we're running out of time. So I've really found it most interesting. And the thing is that it sort of is a good sequel to Paul's
Hmm.
excellent chat last week. So can I thank you very much?
Thank
And
you.
we'll
Uh,
be seeing you around, no doubt.
Thank you. Thank you, dear.
Thanks, Alistair.